mentioned ascertainability. So what is it, and why isn't it in Rule 23?
This is Brendan Kohler from Cozen. So we had mentioned ascertainability as in the context of federal court. So that is not found in Rule 23. It's really an implicit element that was created by the courts, and it looks for, and there's certainly varying law all over the place. In the Third Circuit, it's where I practice, it's extremely strong. In the Ninth Circuit, it's not as strong, but it looks for an objective criteria to identify the class. This can still be used in a no injury type case. We, in that FDCPA case that Rich and I argued, we had asserted that there was no way for a plaintiff to prove on a class-wide basis that each and every debt was for family, personal, or household purposes. It related to an easy pass and debt incurred with easy pass. And the question is, if someone drove through an easy pass without a transponder and incurred a debt, were they traveling for work at that point or for personal, because only one of those debts would have been subject to the FDCPA. And there's, it's without having mini trials and deposing or questioning each and every person that incurred that debt, it's very hard to show that on a class-wide basis.
I want to just to toss in a point on ascertainability. For those of us who have lived and breathed class action law for a very long time, and paid attention to relatively recent rulings, there's usually been a sense that most circuit courts were saying that you needed to have an ascertainable class, and that if you had fundamental problems with your class definition, couldn't figure out who the class members were or weren't, you didn't have a problem. The problem today is that a number of courts are beginning to, question that, and there's still, and there are courts of appeal that are basically saying that you can have a 23B3 class even in the absence of an ascertainable one, and that's very problematic. It's never been an issue. I shouldn't say it's never been an issue, but it's far less of an issue in a 23B2 class, which is a very small percentage of the classes that are out there. But for those who think that ascertainability is something that is going to knock out your class action, you may be very surprised and disappointed to see that in the circuit in which you're defending, that's no longer a requirement.
Yeah, it really is very important to know the law in the circuit that you're in which your case is pending, because there could be dramatic differences from circuit to circuit. I mean, we know the Third Circuit is you're in the Third Circuit, you're golden as far as ascertainability, but elsewhere not so much. And it likely will be an issue that the Supreme Court's going to take up.